Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications, exercise number 5 and 6 on the speed of 90 words per minute. Start. Having noticed the salient fact on which there is not much dispute, this court is firstly constrained to observe that there is no material or evidence to indicate what steps the corporation took between 30 April 1996 to 3 February 1998. There is not one shred of evidence to indicate as to whether any notice was issued to the petitioner during this period to participate in the disciplinary proceedings. As noticed above, although the order dated 24 April 1998 asserts that various dates had been fixed by the inquiry officer appointed on 17 February 1997, no such notice has been placed on the record, nor have details of any such notice been alluded to or disclosed in the affidavit filed in these proceedings on behalf of the corporation. Even the order sheet which stands appended along with the counter affidavit of the corporation refers to dates which were fixed in 1996. On the above state of the record, the submission of the learned counsel for the petitioner that the disciplinary proceedings were revived only in 1998 after a long spell of unexplained silence and inaction appears to have force. On 17 February 1998, the corporation, although being fully aware of the pendency of the disciplinary proceedings, proceeded to pass an order holding that the petitioner would be treated to have retired from service with effect from 31 January 1998. If the petitioner was permitted to retire with effect from 31 January 1998, this court fails to comprehend what authority inhered in the corporation to proceed with or continue the disciplinary proceedings or to inflict any punishment upon the petitioner. As noted above, no statutory provision, rule or regulation prevalent in the corporation was referred to or relied upon to sustain the continuance of the disciplinary proceedings after the retirement of the petitioner on 31 January 1998. Once the petitioner had retired from service, no authority vested in the corporation to continue with the disciplinary proceedings which had been initiated against the petitioner. Retirement of an employee cuts the cord which connects the two entities and serves all relationship of master and servant or employer and employee. The retirement of an employee brings the curtain down upon the relationship of employer and employee. Once this event occurs, no further jurisdiction or authority vests in the employer to inflict any punishment upon the employee thereafter. Even otherwise, the following facts also need to be highlighted. Admittedly, The inquiry report was submitted on 19 February 1998. A reading of the said report, which stands appended as Annexure 14, clearly shows that the inquiry officer has not recorded his satisfaction in respect of the guilt of the petitioner on the basis of any material or evidence on record. The only conclusion recorded by the inquiry officer is that since the petitioner did not cooperate with the disciplinary proceedings and that from his conduct it is clear that he does not want the proceedings to be concluded, he had no option but to record a finding that the charges stand proved. It is to be noticeable that Honorable Supreme Court, while laying down the law that in contempt jurisdiction no positive mandatory direction can be issued outside the scope of the order which is being alleged to have been violated by the authorities, has elaborately observed therein that the purpose of contempt jurisdiction is to uphold majesty and dignity of the courts of law. It has further been observed that the Contempt of Courts Act has been introduced for the purposes of securing the feeling of confidence of the people in general for true and proper administration of justice in the country. Honorable Supreme Court has further held that it is to be kept in mind that the court, while exercising the jurisdiction to punish for contempt, does not function as an original or appellate court for determination of the disputes between the parties, and thus contempt court is not entitled to enter into questions which have not been dealt with and decided in the judgment or order, violation of which is alleged. The ratio of the said judgment of Honorable Supreme Court in the case of Rakesh Prasad Supra is not being disputed by the learned counsel appearing for the respondents, and in my opinion as well, it cannot be disputed. It is not in dispute that the contempt court cannot grant any substantive relief or issue any direction in respect of the same without proper adjudication of the dispute. If any such mandatory direction is issued which is outside the scope of the order or judgment which is said to have been violated, such a direction would be without jurisdiction and would not be binding. Having observed as above, what needs to be considered in the facts and circumstances of the case is as to whether the direction issued by the Honorable Contempt Judge in the order dated 9/4/2012 directing the Basic Education Officer, Ambedkar Nagar, to continue with single-hand operation of the salary account can be termed to be a direction without jurisdiction adjudicating upon an issue, or it would be construed only to be a direction issued in the aid of the High Court for ensuring compliance of its order dated 14/12/2011. The circumstances in which the order dated 9/4/2012 was passed by the Honorable Contempt Judge have been noticed in the said order itself. At the cost of repetition, it may be observed that even after passing of the order on 26/3/2012 directing their in single-hand operation of the salary account, payment of salary to the teaching and non-teaching staff could not be ensured, and in fact a dispute arose during the court proceedings before Honorable Contempt Judge on 9/4/2012 when the check as presented by the Basic Education Officer was returned back to him, noticing the dispute between two managers. In such a situation, I am of the considered opinion that the direction issued by Honorable Contempt Judge for continuance of the single-hand operation of the salary account in the order dated 9/4/2012 was not a direction issued by the court on its own.